How's everyone doing today? It's B with 2B Fruitful Training Group, and today we're going to be going over the difference between a legal estate versus an equitable estate. Now, most people don't realize there is a very large difference between the two, and it does affect the nature and the method that you use to protect and guard the estate as well. So, to best define these different terms, we're going to look to several different dictionaries. One is Black's Law Second Edition. Another is Bouvier's Law Dictionary, 1914. And the third is Anderson's Law Dictionary, 1889. So the first, Black's Law Second Edition, states that an estate is the interest which anyone has in lands or in any other subject of property. It's an estate in lands, tenements, and hereditaments signifies such interest as the tenant has therein, the condition or circumstance in which the owner stands with regard to his property. Estate, second definition. Standing, condition, category, state, status, position, rank in life, degree, as an addition of estate. See addition, necessaries. French, estat, Latin, statites, stare, to stand, state versus bishop. And out of Bouvier's, we have Latin, status, the condition or circumstances in which the owner stands with reference to his property, the degree, quantity, nature, and extent of interest which a person has in real property. It signifies the quality of interest which a person has from absolute ownership down to naked possession. This word has several meanings. In its most extensive sense, it is applied to signify everything of which riches or fortune may consist, and includes personal and real property. Hence, we say personal estate, real estate. In its more limited sense, the word estate is applied to lands. It is so applied in two senses. The first describes or points out the land itself without ascertaining the extent or nature of the interest therein, as my estate to A. Bouvier's 1914. And continuing, the second, which is the proper and technical meaning of the estate, is the degree, quantity, nature, and extent of interest which one has in real property, as an estate in fee, whether the same be a free simple or fee tail, or an estate for life or for years, etc. Koch says, estate signifies such inheritance, freehold, term of years, tenancy, by statute merchant, staple, illegit, or the like, as any man hath in lands or tenements, etc. Estate does not include rights in action, but as the word is commonly used in the settlement of estates, it does include the debts as well as the assets of a bankrupt or decedent, all his obligations and resources being regarded as one entirety. See Davis's Heirs versus Elkins. Also, the status or condition in life of a person. See Estates of the Realm. It's interesting to note that it includes all the debts and assets of the bankrupt or decedent. I highly suggest that everyone go and look into HJR 192, Public Law 73-10, and everyone take a look into the Coinage Act of 1965, as well as looking into President Nixon's suspension of the gold standard with the dollar in 1971. Equitable estate, as opposed to a legal estate. An equitable estate is defined in Bouvier's Law Dictionary as a right or interest in land, which, not having the properties of a legal estate, but being merely a right of which courts of equity will take notice, requires the aid of such court to make it available. These estates consist of uses, trusts, and powers. They possess in some respects the qualities of legal estates in modern law. A contract for the sale of land gives the buyer an equitable estate, an interest which he can resell or dispose of by will, etc. His title is good against everyone except, quote, a purchaser for value without notice. Bouvier's 1914. And out of Black's Law 2nd edition, equitable interest. A real right, but not a legal right, in a property. Examples are a life tenant or the beneficiary of a trust, known also as an equitable estate. That being said, an equitable estate is exclusively seen and heard in equity, in a court of equity. Courts of law do not recognize private trusts, and as such they have to be handled accordingly, as there's no adequate remedy at law. And another interesting note is an estate, in the two definitions in the way it's defined in Bouvier's 1914, with the extensive sense and the limited sense. The extensive sense encompasses nearly everything and could include almost all types of interest that someone, if they be a bankrupt or a decedent, if they be declared dead, could encompass. In its limited sense, it refers to lands. And in the past, it's interesting to note as well, slaves were treated as according to the land because they were treated civilly dead. This was primarily due to the slaves' incapacity to own or hold property for their own benefit. As such, their property was alienated and an estate was created for said slaves. Said estate would have been legal as it arose out of operation of law, as opposed to an equitable estate, which would be formed either through contract or through an express method of declaration, a transfer of property, or another method.